All right, thank you, Madam Clerk. Good afternoon. My name's Robert Wiedemeyer. I'm in the middle section from Nashville. My colleagues today are Judge John W. Campbell Sr. From Memphis on my right, Matthew J. Wilson from here in Madison County on my left. We are very appreciative of getting an early start because of this weather situation. Some of us are going to be driving into the weather, and some of us are going to be trying to get away from it, headed back toward Middle Tennessee, but we're glad we could get started. 20 minutes per side. We've read the briefs. If you want rebuttal time for the appellant, let us know. The clerk will keep up with it for you, and the light will indicate how it's going for you. Any preliminary matters?
Yes, Your Honor.
Okay, go right ahead.
Public Defender Raines has an introduction to make.
Good afternoon, Your Honors. If it's okay, I'll just make a quick introduction from back here.
Certainly.
I'm Mitch Raines with the Public Defender's Office in the Appellate Division, and today we have Ms. Barbara Bailey Turner, who's going to be arguing, I believe, the second case on today's docket. She's an intern with our office. This is her third stint actually with us, and because she's come back and worked so hard with us for so long, she has written the brief and essentially handled the case that's going to be this afternoon from beginning now all the way through oral arguments. So we're excited that she's been able to work so closely with our office and that the court has allowed her this opportunity. So, thank you.
All right. Well, thank you and welcome. We're glad you're here. The office where you work does some great appellate work that helps us a great deal, and we look forward to hearing your argument after this case then. All right. Thank you for being here.
Thank you, Your Honor.
All right. So, any other preliminaries? Can we call the next case?
State of Tennessee versus Tondre, Dupress, Ragland.
Good afternoon, Your Honors. Todd Ridley on behalf of Mr. Ragland. If I could have 3 minutes for rebuttal?
3?
Yes.
Certainly. 3 minutes. Let me also say, keep your voice up. You're fine. I've just got a little hearing issue, and just speak. You almost always speak pretty loudly, but
I will try to.
in a good way.
It's strange, the microphone or something, it's making it seem like I'm shouting right now with the sound.
Yeah,
but
no,
I
and
will-
it's different in every courtroom too.
It sure is.
Yeah, go right ahead.
Okay. Today we're here on a single issue on a case that has already been before this court once. We're here on the issue of consecutive sentencing and Wilkerson. The first time this case was before this court reversed the trial court's decision to impose consecutive sentencing and remanded it for a new sentencing hearing for more detailed findings to be made. This case went back to the trial court for that to happen. On remand, the trial court did not make additional findings that would be sufficient under Wilkerson. So the important thing is that Wilkerson and really Pollard and going back even further, Buys, make clear that this court will grant or give trial courts a fair amount of leeway on sentencing issues. And as long as it's within range, they will be afforded a great deal of discretion in making, as long as they make findings, to impose whatever in-range sentence they think is appropriate under the circumstances. But in the limited context of consecutive sentencing regarding a dangerous offender, Pollard and then later Wilkerson make clear that more than just running through the boilerplate sentencing law is required before you can impose consecutive sentencing for that reason. There has to be specific facts and specific findings to justify finding that this particular defendant is a dangerous offender. In this case, the trial court did not make sufficient findings to do that. In fact, the findings made by the trial court at the remanded sentencing hearing are even less specific than the findings that this court found to be inadequate the first go around. And so for that reason, we're asking the court to once again reverse the trial court's imposition of consecutive sentencing. And rather than remand it for a third sentencing hearing, what we're asking the court to do is look at the record that the state has had 2 opportunities to put together, and determine that the state has not met its burden of showing that Mr. Ragland is a dangerous offender, and therefore revert to the default of concurrent sentences and sentence Mr. Ragland to an effective sentence of 16 years incarceration. The reason we're asking this court to do that on de novo review is two reasons, or really a few different reasons. One, because the state and the trial court really have had two different tries at doing this. We really don't think a third try would be appropriate under the circumstances. And another reason is just, in addition to judicial economy, the trial court has been under the impression that the facts that it is finding are sufficient under Wilkerson. We think it would be instructive for the trial court if this court could illustrate for it, here are the things you need to find if you're going to impose consecutive sentencing based on a dangerous offender finding. And more is needed than what has been done here. And based off what the state has actually presented to justify finding Mr. Ragland to be a dangerous offender, there's simply not enough there. And because there's not enough there, again, we'd ask for concurrent sentences. Specifically about Mr. Ragland and why concurrent sentences are appropriate. At this point, Mr. Ragland is 47 years old. This was his first criminal conviction, or I believe even first criminal charge. He has not had issues with the law throughout his life. It is simply, this was an isolated incident that was bad. There is no denying that what he did was not okay, and he should be punished for that. What we're saying is that 16 years incarceration for a 47-year-old man is more than enough to punish Mr. Ragland and serve the needs of society. When Mr. Ragland is released from prison, he'll be north of 50 years old. He will still have these convictions on his record, and he will have had the unfortunate experience of spending time in a TDOC facility for about a decade, probably more. And that, we believe, is sufficient punishment under these facts and based off what the state has presented. Normally, I would keep going, but under the circumstances, if there are no further questions from the court, this is a pretty straightforward case, what we're asking, and there's not really much more in this record than there was in the previous one, and since we don't have a sufficiency challenge in addition to the sentencing, the briefs really spell out the rest of the argument. So if there are no further questions, we'd ask the court to reverse.
Thank you, Mr. Ridley.
Thanks.
General, how are you today?
I'm doing well, Your Honor. How are you?
Good, good, thank you.
May it please the court, Courtney Orr on behalf of the state. I agree with Mr. Ridley that the issues in this case are quite limited. It is whether the trial court properly applied Wilkerson and what the standard of review should be for this court to review. And yes, this is the second sentencing hearing that the court has had the chance to consider this exact Wilkerson issue. In the first sentencing hearing, the trial court simply recited the Wilkerson factors, found that they applied to the defendant, but then made no factual findings on how those factors would apply. In the first appeal, this court noted the lack of factual findings and remanded the case limited to the consideration of the Wilkerson factors to determine the propriety of consecutive sentencing. On remand, the defense counsel noted that the only reason that they were there was for the court to make factual findings to support application of the Wilkerson factors that it had already determined applied to the defendant. And the court made those factual findings. The court found that there were two separate victims in this case, that the defendant fired shots over an extended period of time in a residential area, and that the defendant's actions endangered other people. It's the state's position that those findings, while not as robust as we have seen in some other sentencing hearings, are sufficient to allow this court to apply the abuse of discretion standard of review under Bies. But even if this court were inclined to apply de novo review, you can affirm consecutive sentences in this case. Most of the facts are in the first sentencing hearing or at trial, but the facts in the record show that the defendant shot several times at a moving car in a residential area. In fact, he chased down this car where Ms. Bonds and Mr. White were driving down the street. He stopped the car while it was still in gear, beat Ms. Bonds pretty severely over her head with a gun in his hand, again, while the car was still in gear. While he was beating Ms. Bonds, he pointed that gun at Mr. White, who was in the car. Ms. Bonds was able to get away, and she kept driving, but as the car drove away, the defendant fired several shots in the direction of the car. that was driving down the street. Mr. White bailed out of the car, exited, and then the defendant continued firing shots at Mr. White as he fled the area. The proof at the first sentencing hearing showed that there were several houses on this street and an active church, all within about a half mile of each other. And the proof from all the parties, including the defendant at trial, showed that the defendant began his chase of the car in front of one house, chased it in front of several houses, and then ended up at the church. And at the time of the shooting, the church was letting out of an active church service. In fact, the shooting was interrupted by one of the churchgoers. And indeed, Mr. White, as he was running away and as the defendant was shooting at him, was fleeing towards the church, attempting to get help from those churchgoers, and the defendant told the bystanders, do not help him, do not open the door, and they ignored the defendant and helped Mr. White anyway. We believe that even if this court were to apply a de novo review, looking at the facts in this record, the proof is more than adequate to show that the defendant, or that an extended sentence of 20 years was necessary to protect the public from the defendant's criminal actions, and that the aggregate length of the sentence, 20 years, was reasonably related to the severity of the offenses. Unless there are any questions from this court.
What were the facts the court relied on, articulated?
That there were two separate victims, that the defendant fired shots over an extended period of time and in a residential area, and that the defendant's actions endangered other people, the churchgoers. Yes. So unless there are any further questions, we ask that you affirm the judgment of the trial court.
All right, thank you,
Thank
General.
Very, very quickly, I would say the biggest problem with the state's position in this case, and with the facts that were articulated by the state in arguing for consecutive sentencing here, is that the trial court did not make any findings that are consistent with what the state just laid out. The trial court's findings are limited to about 2 sentences, where yes, the trial court did find that there were 2 separate victims. That, frankly, went without saying, given the convictions in this case. There was an aggravated assault for Ms. Bonds, and then there was this attempted second-degree murder for the other victim. That, again, went without saying that there were 2 victims. So that, in and of itself, doesn't seem like something that would justify consecutive sentencing. Second, the state said at the tail end that 20 years was appropriate in this case, or commensurate with the offense. That's not a finding that the trial court ever made. The trial court never said anything that would explain why a 20-year sentence rather than a 16-year sentence is appropriate here. The trial court didn't offer anything on that, other than to say, I think that's enough. I think that was the exact quote. I think that is sufficient, when the trial court found that this endangered other people. But what was lacking was proof that this endangered other people. The state just laid out, well, there were houses nearby and there was a church service to get nearby. But we didn't hear any proof from those people saying that they were endangered, or that proof from someone living in those houses that they were endangered, or that something else was going on. That just never really came up in this case, and it didn't come up because the state chose, for whatever reason, not to put on any proof regarding those facts. And without that kind of proof, we just can't make the kind of findings that the state is now asking this court to make. And since the trial court didn't make those findings in the first place, we don't think it would be appropriate for this court to all of a sudden make findings that, despite having 2 chances to do so, the trial court itself never actually found. And for that reason, again, we're asking this court to say that 16 years is a more than adequate punishment for the offenses Mr. Ragland was convicted of. And there's nothing that the state has presented today or at trial that would explain why a 20-year sentence is necessary as opposed to a 16-year sentence. And for that reason, again, we'd
You
ask.
said that there was no, I understand there was no additional proof submitted during the sentencing hearing.
Correct.
But there was proof at trial about, if I remember correctly, about the minister or about the people of the church when the shooting was going on
Oh, okay, so.
at the original trial.
At the original trial, so the proof that actually came out from the church was in some ways favorable to Mr. Ragland. So the proof is that one of the women who got out of the church saw Mr. Ragland, saw the very inappropriate behavior he was engaging in, told him to stop, and he did. And she described him as polite and respectful. Again, we're not saying that what he was doing was okay or he shouldn't be punished for it. But the proof at trial regarding the church getting out is coming from a woman who was leaving the church and described Mr. Ragland as polite and respectful and did as she asked. So I suppose the point would be that the proof at trial sheds some light on this issue, but to the extent that it doesn't paint nearly the dark picture that the state's now trying to paint. And in fact, to the extent that there is proof about what threat this posed to other people, the threat seems to be, or the proof seemed to suggest that Mr. Ragland was intent on harming these two people, but was not interested in hurting anybody else and was not trying to endanger anybody else. And when told to stop, he did in fact do so. Again, this is not ideal behavior, and we are not asking for it to be celebrated or applauded. What we are saying is this is a 16-year crime, not a 20-year crime, and the state did not do enough to turn this into that. And for that reason, again, we'd ask the court to reverse and impose concurrent sentences for a 16-year total sentence. Thank you.
Thank you, Mr. Ridley. Call the next case, please.
State of Tennessee versus Charles Jordan II.